the topic of this paper, and there's a written paper that will be available. In fact, it's been accepted for publication. I've got a little bit more work to do to finish that off, but it'll be out in the next month or two. And it poses the question, do super fund trustees owe a duty to merge funds? As Dimity alluded to, this is an issue that at least one version of this question has been rehearsed quite widely in the press and by the regulator. In fact, the regulator has gone so far, Ms. Rowell, had to say that, and this was some years ago, but there has been repeated multiple times since, that APRA will remain on ensuring that all trustees are proactively considering their future strategy and putting in place plans to address the issues ahead. In some cases, this may mean for a hopefully graceful exit from the industry. One wonders what a graceful exit from the funds management industry would look like, but there's a very clear push by the regulator to have trustees consider their future, to consider whether the mix of products and services that they provide are in what the regulator calls the best interests of their members. So there's a strong push that has been also now manifest in a number of legislative initiatives. Together, they're often called the member outcomes initiatives. There's actually quite a few things in that portfolio of initiatives, and I'm going to be looking at just a couple. This, however, is not the start of the story. In fact, the story, if you were to track it back, actually goes back over several decades. If you go back several decades, you find that there were a very large number of superannuation funds, many of them relatively small, operated by employers, particularly post-1993, where employers were required to make contributions to superannuation, the early days of the superannuation guarantee. But even since 2004, which you would regard as being a more modern stage of the superannuation systems, the last 15 years or so, we've seen a tremendous decline in the number of trustees. The RFC, that's a reference to, it's the regulatory language for superannuation fund. So the large superannuation funds that are regulated by and supervised by APRA have been a tremendous decline. In part, that was driven by an introduction in 2005 that trustees needed to be licensed as though they were financial products or services providers. That drove a lot of players out of the marketplace, and in particular, the blue bar there, which represents corporate funds. So it saw a lot of employers just decide that they weren't in the business of superannuation, therefore they should gracefully depart. And so there were a variety of means in which they were able to do that, either by terminating their funds and transferring their members, or perhaps merging funds, or engaging some other transactions. But the result has been that over time, there's been this tremendous decline in the number of funds. In 2010, there was some further stronger super initiatives, so-called, that also increased the regulatory burden and arguably encouraged some funds or some trustees to pass their responsibilities to someone else. In 2018, we had the spectre of the Productivity Commission, or who looking at the structure of the industry, came to the overall conclusion that although the size of the industry had grown dramatically, and that there hadn't been any major failures or problems, nonetheless, the industry would be more efficient, and the economies of scale that ought to have accrued to members would be more available if there were fewer larger funds. So there's a context for this pressure for trustees to consider mergers. What my paper looks at, though, is to say, well, there's this pressure, but does that pressure go so far as to constitute a legal duty on trustees to pursue mergers? Coming from more of a traditional trustee or trust law background, that's a kind of curious statement, because traditionally the law has actually been intent on keeping trustees performing their duties. It's been relatively difficult for trustees to relinquish their duties either by retiring, you can do so, but it's not straightforward, or by transferring members or beneficiaries to another trust. So traditional trust law doesn't deal with this particularly well. In the superannuation context, most funds, but not all, and we saw this problem with IOOF at the end of last year, most funds have a power in their deed that empowers the trustee to execute or undertake a successor fund transfer, an SFT. For those funds, it's possible to argue that they at least have a power to give effect to the mechanism by which they could merge or they could terminate their fund and pass the members across to another another trustee. So does that power have sufficient impetus behind it as to become a duty? I would suggest in a general law, the answer is no. The paper goes through all the background to all of the cases and why that is. But I suggest that the power to undertake a successor fund transfer is not a power that the general law, at least, would regard as being a continuous power requiring continuous attention, scanning the horizon, looking for merger partners, but is actually a power that is catalyzed by an event. The event might be an exogenous event, like an invitation to SFT from another fund. It might be a change of position for the employer, for instance, or it might have some other source. My suggestion, though, is that this type of power, this power to SFT, is not one like the investment power that requires continuous attention. It's not one that requires attention on some regular periodic basis. So every year you sit down and work out who gets the income that's been earned as in the power of appointment. It is rather one that is only enlivened when something else happens. The trustee forms a view that something ought to happen and uses that power to give effect to it. That's the position at general law. The position in the statute and in the regulatory regime is rather different. Several things have happened, the most important one of which is that under the prudential standards, to cut to the chase, under the prudential standards, it is now the trustees are now required to perform annually an assessment of or to create a business plan and to perform an assessment against that business plan of their past performance and also their future prospects. That seems to me to change as rather, because one of the factors that they have to have regard to amongst a range of others is the extent to which scale or lack of it is impeding their ability to achieve the best interests of members or to pursue the best interests of members. That seems to me to rather change things. It means that each year trustees have to turn their minds to that question. And it's suggested in the material that APRA have produced around that new duty, that, or rather slightly reformed duty, that trustees would have a look to the cost structures and their future distribution of their fund, etc., and do something about it. Now, when you think about that from a practical perspective, not from a formal legal perspective, what could they actually do? It's not like they can suddenly prime their performance and get better performance per se. That the investment, we all know investment performance is somewhat stochastic, but it's also not something that you can simply pedal harder or push faster and and performance will be better. It doesn't work like that. So you're really looking at cost containment. What could you do to reduce costs? Well, you could try to renegotiate contracts, but you would assume, I think, that many of the funds or most of the funds have already done some job at renegotiating a contract. What makes that harder, though, is that each year the trustee is required to disclose their assessment of their position. If they are feeling under pressure and feeling a need to renegotiate, that will have to be articulated, which means that the parties with whom the trustee is negotiating will know precisely why it is that they're negotiating. And every time I've gone into a negotiation where from a position of weakness, it's been pretty obvious that the other party has known that and pushed back. So it seems to me unlikely that there is an endless flow of cost recovery and cost reduction strategies available to trustees. It seems to me far more likely that that there might be some, but that those will quickly be extinguished or quickly be exhausted. The result would be that trustees may have a year or 2 years perhaps in which to drive down costs and to do things, but that unless there's some material change in circumstances, it's quite unlikely that they're ever going to get out of the death spiral that this is putting them into. Much more likely is that after a period of a year or two, the pressure to find a merger partner is going to be the only strategy that is left open to them. And so, in a practical sense, it seems to me that there will be a positive duty to seek a potential fund merger. That might have been implicit in the way that the scale test that used to be applied to superannuation funds works, but it's much more this case now. It is still implicit, but when you look at what other levers trustees will have, they will quickly get exhausted. Note, I'm not saying that trustees will have a mandatory duty to merge funds. So it's not as though they're going to have to, if they're approached by someone, they'll have to accept that. There is still a responsibility that they exercise their powers and perform their duties in the best interests of members. So it's not saying that, but it is saying that practically trustees will have little option very soon, but to be out there actively scanning the horizon looking for potential mergers. The paper canvasses all of that in a little bit more detail than I can today. What does that mean for fund trustees? I'm not quite sure what the picture up there really has to do with this slide, except I saw it when I was looking for it, and it's from Utah apparently. It just struck me as being an amusing view on merging, particularly in Sydney traffic. It's something that's I wish we saw more often. So what does it mean for fund trustees? It means that you're going to have to take peer benchmarking much more seriously, because you're going to need to be able to understand precisely how your fund compares to others if you're going to want to be able to resist the pressure from APRA to seek a fund merger. That means it needs to be more systematic, it needs to be continuous, it needs to look at a variety of different factors. Whether that opens up an opportunity for consulting firms to provide analysis of that, I think there's already some evidence of that. But it's going to need to be much more serious attention to this than there has been in the past. We need to change governance processes, and we might even need what we call strategy committee, perhaps, although it'll be, sotto voce, it'll also be a merger committee. That is a standing committee in order to demonstrate a commitment to seeking out opportunities as they arise. We may also need independent experts, because one of the challenges that often arises in this space is that the directors of the trustee company are in a very difficult position, having been nominated by some external party to represent them on the board. It can be very difficult for them to put themselves out of business, because it's not just them that are losing their position. They are also de facto affecting adversely the position of the nominee, or not sort of the nominator entity. The other thing that will come up is that niche marketing strategies will be much more difficult. For a long time, I've been a proponent of the view that there is a place in the superannuation system for funds that cater to particular niches, particular types of member, where their needs might be different than the general population. It's going to be very difficult to run that kind of strategy, because you're going to have to demonstrate that the benefits of the tailoring that you can do for your client and your member base still represent good value. What are the regulatory implications? Well, one of the hobby horses I've had for a little while is that whilst I think the heat maps that APRA produce, where they report the recent performance, recent fees, recent costs, and so on of all the funds in the MySuper product space, whilst I think there's some value in collecting that information and APRA having it, I'm not sure that it's particularly productive for that to be public, insofar as it would tend, it seems to me, to create the prospect of a run on a fund that was signaling through its heat map results that it was perhaps not as strong as it could be. I'd much rather see that conversation happen behind closed doors than in the pages of the Financial Review or the Sydney Morning Herald, as happened last week when once again APRA announced that it had, through its action in creating the heat maps, had driven down prices in the marketplace. Perhaps more subtly, and this is something that Rob and I and others have worked on for some time at various, is that APRA has statutory objectives in relation to competition that it doesn't seem to really understand what to do with. So the questions that come out of the analysis in this paper have to do with, is it really the case that having big, large funds that cater to a lot of different types of members, is that really a good thing? We've seen the minister argue that it is, that it makes them more resilient to industry issues. So for instance, people in the hospitality industry and the retail industry being more affected by layoffs in COVID and the lockdown. If they were all in a big multi-industry fund, the industry fund would be much less affected. I'm not sure I buy that entirely, and I don't think APRA really has justified its view about what the ideal industry structure is. I'm also concerned that we're creating a too big to regulate problem that we've got in a range of other financial services and other industries, where the entities operating in these industries are just simply too big practically or politically to actually rein in. It's also interesting to speculate as to whether funds that are large are actually better behaved. Certainly there's plenty of evidence in recent times that they may not be, that size doesn't really make a difference on that front. And finally, I just raise the question is, how accountable is APRA in this process of euthanizing funds?